My name is Patrick Korody, and I'm at Korody Law in Jacksonville, Florida. We are a security clearance defense law firm, and we have represented individuals throughout the DoD as well as the intelligence community. The purpose of this video is not an advertisement. You're not going to hear any flashy music or montage or anything. I'm here to give you some straightforward advice and put you in the best possible position to retain your security clearance or obtain your security clearance. The purpose of this video is to discuss what is called an SOR, or Statement of Reasons, how you receive it, how you respond to it, and what the next steps are. So first, let's talk about a Statement of Reasons. I'm holding a Statement of Reasons from a Defense Counterintelligence and Security Agency, the DCSA. That is the DoD arm that handles all the security clearance adjudications. What you have here is a cover letter, all right? It's a cover letter that was addressed to an individual, in this case, a contractor. And what it says is essentially the matter of eligibility for the security clearance is at issue. The DCSA AVS, or the Adjudication and Vetting Services part of the DCSA, has made a preliminary determination that it is not clearly consistent with national interest for you to have access to classified information or a position of trust. As such, the enclosed Statement of Reasons sets forth why you should not be granted a security clearance, or why, if you're a holder, that security clearance should be revoked. Now, it also tells you must do certain things, and you must send back a copy of the Statement of Reasons with admissions or denials. So you get this letter. It's normally given to you by your security clearance manager. It's forwarded along with a password. You open it. It's got this cover letter. It also has a receipt that the employee has to sign at the bottom saying that they got the Statement of Reasons, and that triggers a time period to respond, which is normally 20 days. Then you have the Statement of Reasons, and this one is redacted with my client's information on it. But at the top of the Statement of Reasons, it'll have the security clearance holder or the applicant's name. It also has a case number. In this case, it says ISCR. ISCR stands for Industrial Security Clearance. That's the contractor side of DoD clearances. And basically, it reiterates that a review of the eligibility for security clearance has been made, and that they find that it's not clearly consistent with the national interest to grant access to classified information. The case will be submitted to an administrative judge for determination as to whether or not to grant, deny, or revoke the security clearance. And then they give you the reasons. The first thing that they do is identify the guideline and give you a summary of the guideline. For example, in this case, it's Guideline H, and it talks about the illegal use of controlled substances. Under that number paragraph with the guideline, there are subparagraphs that make specific factual allegations. They, in this case, for example, it says from on or about July of 2020 to the present, you use marijuana with varying frequency. That's the allegation. So when you get a security clearance SOR, you have to first review it closely, review the instructions, and then you get to the actual allegations as the reasons as to why they are saying that they should revoke or not grant your clearance. When you're going through the allegations, you should take notes. And the notes should be based on the factual allegations in the paragraph. The allegations are pled, and the attorneys and the judge, the administrative judge from the Department of Hearings and Appeals, the wing that hears the security clearance cases, we all refer to these as the paragraph and subparagraphs. For example, paragraph 1, like I said, Guideline H, drug abuse. The first allegation is a subparagraph A. We all refer to those as paragraph 1A. Let's say there was a second paragraph that said Guideline F, financial issues. And then there would be subparagraphs A, B, C, D, and E, and so forth. We would refer to those as paragraphs D, or paragraphs 2A, 2B, 2C, and so forth. You should start learning that nomenclature, because if you go to a hearing, that is the way that everyone's going to talk. And especially if you later submit documentation down the road, and we'll talk about whether or not you should submit documentation with your SOR response. You should always identify which paragraph and subparagraph that documentation is related to if you can. So the first thing that you're going to do is you're going to respond with the receipt saying, hey, I received the statement of reasons on this date. And why is that important? Because often security managers sit on it for a week or two. Maybe they're on vacation. Maybe they just didn't get to it. But sign the receipt saying, I got it this day. That signs or that starts the timing that you have to respond. Now, your actual response can be one of two ways. The first thing is you can make a copy of the statement of reasons, and you can literally write on it, admit, deny, or deny, whatever it is. And you can send back the statement of reasons with your handwritten notations on it, and then a copy of the Doha election form. And I always almost universally recommend to my clients that they elect a hearing before an administrative judge. I do that because in most cases, it provides more time to mitigate the concerns. It also gives the clearance applicant or holder the opportunity to appear and answer questions and explain themselves. And remember, security clearance is based on the whole person concept. And you get a lot more out of seeing someone and listening to someone than you do in a paper response. It has also been my experience that most paper responses submitted by applicants, especially when they aren't represented by clients, are very disorganized, hard to follow, and the judges simply don't understand what the applicant is saying. And remember, at a security clearance hearing, the burden is on the applicant or the security clearance holder to demonstrate that it is or remains clearly consistent with national security interests that the clearance be granted. So let's go back. I talked about the admission or denial. At the end of the day, what the DCSA AVS wants is they want a response to each subparagraph and whether you admit or deny the factual assertion therein. Now, that seems pretty straightforward, and in some cases it is. In some cases it's not. What if an allegation is only partially true? So, for example, the dates are wrong. The location is wrong. Now, there's some schools of thought here. One is that you can simply deny it because the allegation as written is not true. The second is you can deny with an explanation or admit with an explanation, which is, hey, I deny that this happened in June of 2020. However, I was arrested in June of 2021. And you understand that maybe there was a Scrivener's error or for some reason their data is wrong and they're simply off by a year. Now, I only recommend that when you are certain that this was simply some type of clerical error or they got something wrong and they really meant to allege something that is true. And if you're confident after reading it that this was a Scrivener's error, clerical error, correct them. Why? Because it demonstrates your candor as an applicant, your honesty, your integrity. Those are qualities that the administrative judge is looking for. If you deny things that are clearly true, that will undermine those qualities. So as you go through, you have to admit or deny each subparagraph. And you can, as I said, write on the statement of reasons, or you can do a separate letter. Now, I want to tell you that responding to the statement of reasons is not your opportunity to rebut or mitigate or get them to change their minds. And the reason for that is you have two options. One is to elect a hearing, or the second is to request a decision on the written administrative record. They call that a form, a file of relevant material. And those are your two options on the election form. There's not an option that says, hey, I'm going to submit some stuff. I'm going to ask you to reconsider. Now, are there isolated cases where that may be appropriate? There are. For example, in a financial case, if they allege a debt is unpaid, but you have documentation where the debt is clearly paid, maybe you attach that documentation, you write on it subparagraph 2.c, right? Because that's the relevant debt. This document shows I paid it. You deny the allegation because it says unpaid, you attach that, you submit it, and maybe that allegation goes away. It is not a time or place to submit a lengthy written response as to why the adjudicators who made the initial determination that the clearance should not be granted or revoked are wrong. You'll have that opportunity. It should be before the administrative judge. Now, why do I say elect a hearing before an administrative judge? The reason for that is not only, like I talked about, the opportunity to appear before the administrative judge, but it normally takes many months before your hearing is scheduled. If your concerns are financial, if they are drugs, if it's past criminal behavior, if it's medical issues, mental health, this time gives you more time to mitigate any of the concerns, as well as establish a meaningful track record of whether it's financial responsibility, repaying debts, being drug-free, being alcohol-free, mental health issues, you're in counseling, you're on medication, the medication's working. So it gives you this longer period of time to both address the issues and establish that meaningful track record, which directly goes to whether or not you remain or are a security concern. So you've now answered your statement of reasons. You've made your election on the form. What do you do with this? Well, you need to get it back to the DCSA AVS, and you can do that by mail. There's an address in the form. There's also an email address for DCS AVS that you can find online. Keep a copy of what you send for yourself, and you wait. And probably 30 to 60 days later, you'll be contacted by a lawyer. We call it the department counsel. That is the lawyer that is essentially prosecuting your security clearance case, who will appear before the administrative judge and argue that you should not be given a clearance or your clearance should be revoked. After that, you'll eventually be contacted by the judge or judge's assistant to schedule the clearance hearing. And that's normally scheduled 30 to 60 days out. So now, where do I come into this? Why hire a lawyer? How do I know much about this? Why do people come to me? I think people come to me specifically because I've been doing this since 2009. And my background is Navy. I've held a security clearance. I've applied multiple times for clearances. Everyone that works at my law firm is a veteran who has held a security clearance. And most of the lawyers on the other side of the judges, they're also former military lawyers. And we all understand the issues, and we understand the types of evidence that's persuasive to mitigate any security clearance concerns. When should you reach out to a security clearance lawyer? Well, I think you should reach out to them as soon as you get that cover letter with the statement of reasons. And why is that? Because that is when the work really should begin on your part to mitigate the security concerns, those guidelines. And the reason that you should start to address the security clearance concerns at that time, because some may take longer than the 30 days to figure out. Some may require specialized knowledge to understand how to mitigate them. For example, if it's a drug or alcohol case, do you need a drug or alcohol evaluation? Do you need treatment? Do you need to get through a treatment plan? You may say, well, I haven't drank for a year, but that's just your word. If you have a drug and alcohol evaluation from an expert that says, I evaluated the applicant under these criteria that are standard in my field, and the applicant does not suffer from an alcohol use disorder and requires no treatment. Maybe they say this person has a use disorder, and we need to get them into an outpatient program. And they get you into an outpatient program. By the time the hearing comes, you've completed 15 classes, you've been sober for 6 months, and you have this track record established. Maybe it's because you have financial issues, and you read the statement of reasons, and this is true. It says that you owe Capital One, $2,000 that have been charged off. And you're saying, I have no idea what that is. You need to dispute that. You need time to dispute that and figure out where that debt came from, the origin and nature of it, and challenge it if it is in fact not yours, or if it is yours, take reasonable steps to address it. You need time. And you may need assistance from a lawyer like me. Of course, a security clearance hearing is like a mini trial. And you benefit from having an experienced security clearance defense attorney representing you, making opening statements, presenting your evidence and witnesses, questioning you as the applicant, preparing you to testify, asking you some of the questions that are anticipated from department counsel or the judge, making the closing argument as to why it's clearly consistent that you are granted or retain your security clearance. It is like a mini trial, and if you've never been through it before, it is challenging, it is tough, and you must be prepared. Now, I've had people say, well, I'm going to complete the SOR, and then I'm going to call you once I get notice of the hearing. You can do that. That's not recommended, and I'll tell you why. First, it all starts with the SOR. Well, really, it starts with anything that comes before the SOR. An applicant interview by the background investigator, interrogatories from the department counsel. Maybe you get a request for supplemental information from the DCSA AVS. That is really when you know, hey, something may not be right. But starting with the SOR, especially, you're admitting or denying things. If you admit something, that is something that is going to bind you later at the hearing. It's also the time to start the strategic discussion about how to win your case. What needs to be done? What are we going to accomplish in the next 3, 4, 5, 6 months? So when that hearing comes, you are going to be fully prepared. Your case is going to be fully prepared to address the allegations and the reasons why they say that you should not be granted or your clearance should be revoked. I'm attorney Patrick Korody. I can be reached at 904-383-7261 or Korody Law, KORODYLAW.com. Again, just here to give you some practical advice. If you have an SOR, we offer a free consultation. You can send us your SOR. We'll talk you through it and see how we can help.